Good afternoon, everyone. I'm Chris Gant Sorensen, and I'm here with Perry McLennan and Demetrius Pyburn from the HSB Employment Law team. I will say to you that today is also Earth Day and Administrative Professionals Day. So make sure that you are acknowledging your administrative professionals and contemplating the earth. We are here yet again to talk about more COVID-19, and surprisingly, but not or amazingly, but not surprisingly, there is new things we've got to cover. And so just please, as always, keep in mind that our discussion here today is not legal advice. It's us talking about general legal principles and as they may be applied to specific factual situations, they may differ. So you certainly cannot take anything that you're given today here as legal advice. Please make sure to take note of our COVID-19 resource pages on the HSB Law Firm site, as well as the South Carolina Employers blog, so that you can stay up to date with the happenings as we learn them and post about them. And with that, I'll hand it over to Perry. Thank you for coming, though.
Thanks, Chris. Good afternoon, everybody. Nice to be with you all again virtually. I think everybody's getting accustomed to doing these Zoom webinars, and it's been a really good way to stay in touch with our clients. We really wanted to do the webinar today really as just kind of a check-in with everyone and to provide some of the latest guidance, and also just some of what we're hearing from clients, some of the issues that are being raised. Things are still changing pretty rapidly. This is going to be a little bit of a hodgepodge presentation today. I'm going to give a brief update on where things stand as of today and talk a little bit about the Paycheck Protection Program, because I continue to get a lot of questions from clients and others about that program. It's not going to be a full in-depth analysis of that issue. Another colleague, Will Johnson, and I did a full webinar on that topic on Monday. The recording of that is available if you want access to that. I've included a lot of the slides in here, though, so much of the information you can find in today's presentation. And then Demetrius is going to talk about some unemployment stuff, because I know that's still top of everybody's mind, particularly as you are thinking about potentially bringing people back to work. And then Chris is going to talk about a lot of the sort of workplace safety and other issues around the employees that you're bringing back to work, which I think is very relevant to everyone right now. So with that, just a kind of a brief update. Most South Carolina businesses are open. Many South Carolina businesses stayed open even during the worst of the pandemic. So South Carolina was not as restrictive as many other states. Governor McMaster's order, listed non-essential businesses that must close, but exempted from that were manufacturers and professional service organizations and things like that. So a lot of our clients have maintained operations, but we had some clients, voluntarily closed due to lack of business. And now Governor McMaster announced on Monday this week that certain retail establishments can reopen. Restaurants are going to be reopening soon. And so most businesses should be at least eligible to reopen. There may be a question in regards to timing of whether or not it's right for your business to reopen at this time. The reality of the health situation, though, is that even though businesses are going to be reopening, we're really still in the middle of the pandemic. If you listen to the head of DHEC speak on Monday afternoon at the press conference, what you heard was the cases and deaths in South Carolina are, plateauing. That they're not, increasing at an alarming rate. but they're still happening. I think yesterday we had, something like 173 new cases reported, and we had also something like 11 deaths. Public health officials are saying that we could see a second wave as social distancing restrictions are eased. And so I think, we're not going to be returning to business as it was sort of pre-COVID. Yes, you may be allowed to be operational. Yes, you may be able to bring your employees back. Yes, some of the customer demand may be back, but everybody's going to be working in really a completely different new environment from a lot of different standpoints. One is obviously workplace safety issues, which Chris will focus on in depth. I think you're going to see an increased focus on that, both from the regulator side as well as just employee concerns. And employees saying that they still don't feel comfortable coming to work. Employees asking about what policies are going to be in place to protect us. All those types of things. There's going to be still, I think, an increase in leave requests. The Families First Coronavirus Response Act is in place through the rest of this calendar year as of now, unless Congress extends it. So even though you're back up and running, and even if we see a dip in COVID, you're still going to have to comply with that. And as we get closer to the summer, I think there's going to be some increasingly complex issues surrounding childcare situations. Otherwise, in normal times during the summer, most employees would be arranging for childcare since schools are closed and have some plan, but those plans may be thrown off due to this. So I think you're still going to be seeing a high volume of leave requests and issues surrounding employee health and well-being. And, as far as what the economy is going to look like, that's anybody's guess. I've seen some people saying that we're going to ramp back up to a great economy pretty quickly. And I've seen other, experts say that, this is going to be a very long-term financial recovery. So I think we're definitely not out of the woods yet. And there could be still some difficult decisions that have to be made in regards to compensation of employees and potentially layoffs as well. I know a lot of businesses are relying on the PPP funding to meet payroll for the next 8 weeks, or are hoping to receive it soon. But that money is really only designed for a 2-month period. So if you've got a 50% reduction in customer demand for your services, 2 months from now, you may be again facing layoff decisions. So that's kind of a lay of the land on where we stand. I made reference to the payroll protection program. I think most everybody is probably familiar with the program by now, so I'm going to be fairly brief in my remarks on it today. But this is the forgivable loan program that was part of the federal stimulus bill that Congress passed. And the idea of the program is very, very simple. You can get a loan amount for basically 2.5 times your average monthly payroll. And the purpose of the program is for you to receive those funds and to pay out those funds to your workers for payroll for 2 months. That's essentially what it is. The idea of the program is to funnel money to businesses to get directly into the hands of workers so that businesses can meet payroll. The application of that can be very, very tricky. But I think it's important to keep in mind that that's the spirit of the law. And I think really, HR is going to be at the forefront of advising the rest of the business on payroll issues, because, all of this is based upon headcount, compensation, payroll costs, benefits, those types of things. So I think, it's really, even if you haven't been a part of the application process for this so far, I think it's really good to have a working understanding about this program. So the slide that you see now on your screen is not updated as of last night. The U.S. Senate late yesterday afternoon passed additional funding in the amount of, they added another $310 billion to the program. So Congress originally appropriated $350 billion approximately, and that ran out pretty quickly. A lot of our clients received those loan funds, which is great, but unfortunately, many small businesses did not receive their loan funds, and they are either have pending applications or did not even get around in time to filing an application. The House is expected to act on this today. President Trump is expected to sign it. If you are not already in the queue for a loan, if you have not applied for one, I would consider now getting your ducks in a row, getting your paperwork ready, and go ahead and getting this submitted to the bank if they are accepting applications. I mentioned the loan amount. It's 2.5 times your average monthly payroll, and you can look at 2 separate periods to determine what your payroll is. The real key of this law is determining what payroll costs are. That determines how much loan money you get. That also determines on how you can use the funding that you get and how much of that funding is potentially going to be forgiven or reduced. So it's an unclear definition. Some things are clear and some other things are not clear, but you can see the definition of payroll costs up there. I think it's important to note that it is gross costs included in your payroll calculation. So it's not net. You're not reducing by withholding. You do use gross costs, but you do not include the employer portion of payroll tax. Those are 2 big questions that we've been getting a lot. There's a cap on compensation. Congress didn't want businesses to use this money and, compensate, money to flow to executives are already highly compensated. So there's $100,000 annualized, $8,333 a month cap. Can't pay anybody more than that with these loan funds. And there's some other stuff. Again, I'm going to move through this relatively quickly given everything that we have to cover today, but there is a lot of information on these slides. One issue to point out to you, I know a lot of our clients in South Carolina have non-U.S. resident workers. So whether they are green card holders or they are working under one of the work authorization programs, visa programs, we still don't have clarity on how those workers are treated. The law states that only U.S. residents are eligible, or only folks that have a principal place of residence in the United States. And so we don't know whether that includes someone who's here under a work visa. One other issue I'll bring your attention is concerning temporary employees. The law allows you to include payroll costs for temporary employees. I caution you to be careful with that because I hear a lot of people refer to temporary employees and they can mean 10 different things by that. When some people say temporary employees, they mean, contract labor that they have through a staffing agency. That's not what's meant by this law for temporary employees. Those employees that are actually employed by a staffing agency, that staffing agency would actually have to go get a PPP loan and pay their employees. You don't get to include those costs, and you don't get to include costs to independent contractors either. And I've got a couple of other, part-time seasonal workers, PEO, whether they would qualify under that. So a common misunderstanding, and I think, what has been an attempt to oversimplify the law is that if I had already laid off employees, which many people did, and I hired them back and restore their wages by June 30th, 100% of my loan amount is forgiven. That is not necessary. Well, that's incorrect. It could be correct under certain circumstances, but there's a pretty detailed analysis that you have to engage in first to determine whether the funds are used correctly and whether it's eligible for forgiveness. whether there's any potential reduction in forgiveness. And then there's sort of a provision at the end that potentially allows you to cancel out the forgiveness reduction if you restore your employees by June 30th. But again, not to beat a dead horse, but just keep in mind that the purpose of this program is from the date you get the loan funding, you should be using that loan funding for an 8-week period for payroll. At least 75% of the funds have to be used for payroll. Other 25% can be used for things like rent, interest, utilities, and some other eligible costs. But really the idea here is to use it for payroll costs. And if you use it in that manner, then the loan is forgiven. It's basically a free grant of money from the government, which is great. Now, if you reduce your headcount during the 8-week period, or you reduce the compensation of your employees by over 25%, you face a reduction in forgiveness. Because again, the idea behind this law is to keep people on payroll. So if you're taking the money and essentially laying people off during this period, then you potentially could have your forgiveness amount reduced. Now, I've had several questions from clients about, okay, well, what happens after June 30th? Say we use these funds to bring back all these employees, and, at the end of June and into July, we still haven't seen a return to our normal business levels, and we're going to have to lay somebody off. There's nothing in this law after you've already received your forgiveness that requires that you maintain employment at any certain levels. So theoretically, if you get, if your bank approves your loan forgiveness on July 15th, theoretically, you could lay off 50 people the next day. That is not prohibited under this law. It's certainly not what is intended by the law, or not really in the spirit of the law, but there's nothing that would prevent that. There's no strings attached past June 30th, or really past your forgiveness date, that requires you to maintain payroll. This is really a temporary program that's designed for a specific, 8-week period in mind. I've got detailed slides here about how you calculate the forgiveness reduction. I think that it's a good idea to review those and familiarize yourself with them, and ask us questions if you have them. I'm happy while Demetrius and Chris are presenting to answer questions thrown at me in the Q&A box, which I should have mentioned at the outset. If you have questions, feel free to utilize that Q&A box, and we'll try to address those as they come in, and if not, address them at the end. But with that, I have one more thing I wanted to. So there are a couple of other, one quick note, sorry, on record keeping. As always with anything with the law, keeping records is vitally important, and keeping records of all PPP funds used, and all payroll records, and sort of, separate accounting of the fact that the funds are PPP funds is going to be really important, both for when you go to ask the bank for forgiveness, but also even if the bank approves it, if there is some kind of, audit in the future about your use of these funds. And the same goes for FFCRA payments. If you're going to be seeking reimbursement for sick leave payments under the FFCRA, then you're going to need to provide records of those payments. So, and also I should mention, payments pursuant to the FFCRA are excluded as payroll costs under the PPP. Those are eligible for reimbursement under the FFCRA through withholding what you would otherwise have to deposit with the IRS on your quarterly payroll tax return. So keep that in mind. There's a couple of other relief options out there if you have not taken advantage of the PPP, or cannot, or even if you have taken advantage of the PPP. I mentioned the FFCRA. We've covered that in these webinars. That's the sick leave law. That's a separate program the amounts paid out under that are reimbursed separately. The Economic Injury Disaster Loan Program is a program directly through the Small Business Administration. That program received some additional funding last night in the new Senate bill as well. You can receive both the PPP and the EIDL, but you can't use funds for the same purpose, and you may have to refinance the EIDL loan into a PPP if you plan to use the EIDL funds for payroll costs. If you are in receipt of PPP funds, you're not eligible for the employee retention tax credit under the CARES Act. If you're not receiving PPP funds, that could be something that you are interested in looking into, which I'm happy to answer questions about that. And then the employer payroll tax deferral, we've gotten some guidance that until you actually have your PPP loan forgiven, you can take advantage of that program up until that point in time. But once your amounts are forgiven, you cannot. So that's a couple of other programs that are out there, and that should be really the bulk of them as far as getting relief goes. All right, Demetrius, I will turn it over to you.
Thanks, Barry. We're going to go over two major updates as it pertains to unemployment and relief for employees, furloughed employees. We'll discuss Executive Order 2020-22, and we'll talk a little bit about how the department is implementing the CARES Act unemployment benefits. We'll start with the COVID-19 support payments under Executive Order 2020-22, which was issued by Governor McMaster on April 8th. After recognizing that businesses were financially strained because of the COVID-19, they had to furlough their employees. And despite the challenges, some employers wanted to offset some of the financial impact by giving some type of payments, which generally the department would treat as wages under unemployment and would offset the wages against the benefit amount, that weekly benefit amount. So through this executive order, employers who were considering issuing what they're calling a COVID-19 support payment, that governor would consider this type of payment not wages, or the department would consider these payments not wages, and the employees would be able to receive these payments and still collect their weekly benefit amounts under the unemployment benefits. And in order for employers to provide these payments, they have to first, it's mandatory, they must submit the plan to the department prior to making the payment. Submitting the plan involved completing the form found on the SEDO webpage and sending it electronically to legal@do.sc.gov. The conditions, the employer is certifying these 4 elements and is certifying that these conditions are met in order to ensure that these payments are not considered wages. The payment must be in response to furloughing the employee, must be for services rendered in the past, must not be obligated to repay the payment under any circumstances, and not obligated the employee to perform act connected with the individual status as an employee. So after submitting this plan to the department, the employers do not have to wait on a specific approval from the department before issuing the payment. But understand that the payments made without the certifications or not in compliance with the executive order may affect the employee's eligibility for unemployment benefits for the week they receive this any type of payment from the employer. Now I'll move forward to the Department of Labor. It's issued several letters. I've recently written a blog on 3 of the letters that come from the Department of Labor, provided guidance and guidelines for states in order to issue the 3 different types of CARES Act unemployment benefits. And I'll go into a little detail on what the Department of SEDO is doing for each type of CARES Act benefits. There's three types: the federal pandemic unemployment compensation, the pandemic emergency unemployment compensation, and the pandemic unemployment assistance. And I'll take each in turn and discuss what the department is doing with each. First, the federal pandemic unemployment compensation, that is providing the $600 in additional benefits on top of the state benefits. The South Carolina Department announced on the 17th that it had paid about $53 million in benefits to about 64,000 individuals who made claims for unemployment. They received their $600 plus if they had to pay for prior weeks. That payout occurred around April 12th and over the course of a few days after the employees begin to receive those payments. And the additional $600 will be paid out. This temporary funding is approved through claims, week claims ending in April 4th, 2020 through claim weeks ending in July 25th, 2020. And one note I wanted to point out on this type of benefit, employees are still qualified even if they receive $1 of unemployment under the state. They still receive the full $600 amount despite how much they're paid in their weekly benefit amount. And this is important if you bring your workers back and you come back as under reduced hours instead of coming back to full time. I believe in our last webinar, I discussed that individuals may still be deemed unemployed if they have reduced hours, if the reduction of hours, the amount that they receive from their employer is less than their weekly benefit amount. So there is an offset after the first 25% of the payment has been made. So for example, if their weekly benefit amount is $300, the first $75, the department will not offset their weekly benefit amount. So if the employee gets paid more than $75, the eligibility for that week is reduced. So if it's reduced down to $1, they would receive the payment from the employer. The department would pay $1 under the state unemployment compensation, and then the FPUC would pay an additional $600. So they would be able to receive unemployment in that amount. And if it is deemed that they received over the amount, so say for example that employee received $325, not only do they not receive state unemployment for that week, they will not receive the additional $600 in additional benefits. Next, I'll talk a little bit about the pandemic unemployment compensation, which provides additional 13 weeks of benefits to those who have already exhausted their state benefits amount. And this funding is effective for claims weeks ending in February 8th, 2020 through claims ending in December 26, 2020. And finally, the pandemic unemployment assistance, which expands the unemployment benefits to those typically not eligible, such as gig workers, self-employed, church employees. That the department has not yet accepted claims. They're working on accepting claims no later than the claims week of April 25th this week. This funding is approved for claims weeks ending in April 4th, 2020 through claims weeks ending on December 26th, 2020. And the key thing with this is the first step in receiving this and determining eligibility for this specific type of unemployment is you have to be denied state unemployment. So people who are applying that are self-employed workers or gig workers, they have to apply through the typical due process and receive the ineligibility determination in order to move forward with the next steps. And as the department implements those steps, they will be contacted either by email, over the phone, or through text messages as to what those next steps entail. They don't have to do anything in addition once they receive that ineligibility, or if they appealed, the appeal will be denied and they will be moved over into the next phase of the process. Last note, as far as gig workers, the Department of Labor, in that letter that they issued, I believe they significantly narrowed that scope of gig worker, because the language states that the benefits are only available for workers that are forced to suspend operations. And workers advocates argue that this guidance significantly limits those options for gig workers, because the apps that they use to find work, such as Uber, Lyft, and some other gig apps, are still operating. And so gig workers who opt to stay at home because they're older or they're otherwise vulnerable may be ineligible for this type of unemployment benefits unless they have proof or be able to show proof from a medical professional advising them to stay at home. So that's something to keep in mind. And I'll transition to Chris, and you can take it from here.
Right. So I am going to talk about OSHA, and I am going to cover safe workplaces, but I thought I would go a little out of turn and talk to you about the OSHA COVID-19 investigation guidances, so that it will drive home the need to follow OSHA's COVID-19 workplace safety recommendations. OSHA actually has issued 8 different items in the last 6 weeks. And I have links to those items at the end of the presentation, so you'll have access to those. I'm going to try to cover them, obviously, in the time we have, enough to alert you to them, but I would encourage you to go to the resources themselves and look at them. So OSHA is setting up and has issued enforcement guidance for performing investigations into any complaints about COVID-19 exposures or unsafe conditions. In addition, on its own, any determination where it's decided there might be a cluster outbreak in the area or at the workforce. So the guidance is specific to citations and analyses and investigations on the basis of following OSHA's COVID-19 requirements or recommendations. And so I am going to cover those pretty thoroughly. That's the one bit of guidance that I'm going to cover thoroughly today. The OSHA investigator will give employers good faith exceptions to things that would otherwise be considered violations. And again, that is why you would want to show that you've complied with their COVID-19 guidance. And those would be your good faith efforts, even if you found a situation that resulted in a cluster outbreak or some sort of other incident that might give rise to a violation. When OSHA performs investigations, they're usually going to reserve it, on-site investigations, going to reserve it for imminent danger situations or ones that involve healthcare providers or first responders. Otherwise, the remainder of the types of investigations they're going to perform will usually involve reaching out to you and opening up a discussion, sending you something in writing, and you having to respond. And then if the responses don't come or they're considered insufficient, they will schedule an on-site inspection. They are doing rapid response investigations. That's actually 62% of all OSHA investigations, and those that would involve sending out an email asking you a number of questions and asking for documents. All right. Whoops. Keely, will you make sure that I have it? There we go. There we go. All right. Oops. Sorry, folks. This is the first time I'm doing this. I did practice beforehand. Perry and Demetrius can attest, right? All right. So here's the OSHA COVID-19 guidance. And I've been talking to a lot of y'all that I work with pretty regularly about this. There is no new standard specifically applicable to what duty of care you need to be exercising in your workplace. You are still obligated under the general duty standard to provide employees with workplaces of free of recognized hazards that are likely or are likely to cause or causing death or serious physical harm. So, of course, COVID-19 has that propensity. In the COVID-19 guidance, they suggest that every employer create a preparedness plan that should be in writing, and then a plan to protect the workforce while continuing business operations. There are a number of recommendations in that plan. The ones that they think are most important for controlling an outbreak on site are going to be environmental and operational controls. And I'm going to talk to y'all about those next in more detail. Then after that, there needs to be an analysis performed on each job position and determining whether or not there is a risk associated with it within the 4 categories that are outlined in the guidance. There are OSHA reporting requirements similar to those that you would have in other OSHA reporting instances. You have to also isolate ill people, and you have to have a process for that. And this would all be in addition to the general hygiene recommendations that most all of you have already implemented. So the environmental and administrative controls, as I indicated, OSHA considers them most crucial. So you're going to be employing high efficiency air filters. Ventilation rates need to be increased. You need to have negative pressure ventilation settings where there's aerosol generating procedures. In situations where you need to protect your coworker or your employees from other coworkers or the public, you need to think about installing physical barriers. You know, you see a lot of those in the grocery stores now, or sneeze guards. You also need to provide alternative customer service outlets or methods where you're able to do so, such as a drive-through window and the like. The administrative guidelines are specifically issuing a COVID-19 policy that outlines when employees should stay home and what employees should report to human resources. The policy ought to also cover general hygiene practices, and it should identify who's considered high risk and encourage them to seek input from HR if they require any additional protections beyond what their job is requiring. And it was going to also require you to outline whatever specific protections you're going to align with each job based on its risk category. This policy needs to also discuss travel. So, you know, all of the things that we've known for some time were important to consider. And then the workplace, besides issuing protections for the specific employees in the specific spaces, could you also stagger workplaces? Could you have half teleworking and half reporting, depending on who needs to show up? The risk categories, therefore, very high exposure, medium exposure, and lower risk. So here you're going to look at the job description, and you're going to also look at actually how it's carried out in your workplace. You're going to determine whether or not, for most of the time, the employees can be 6 feet or more. And there are other risk factors, even if that meets the 6 feet or more social distancing. There are other risk factors that you would want to consider with the specific positions. Obviously, the examples here, healthcare workers and morgue workers, they're going to automatically be considered high exposure. Healthcare delivery and support staff, mortuary workers, high exposure. So all through the guidance they're giving you, these are examples from the guidance of how you should look at who falls into what risk category. It's also important to determine how much exposure the workers are going to have just from other workers, not just in the area where they work, but in the common areas. That's going to also be an analysis based upon any visitors that are allowed in or customers. So it's important to look at really the employee's whole day from beginning to end when they're with you. When you look at the COVID-19 guidance, it suggests that really the only category that the 4 different risk categories suggest social distancing as a possibility would be the low risk. So in other words, just sort of a safe rule of thumb would be if social distancing can't be maintained while the employee is performing their duties most of the time, then you're going to need to give them PPE to protect them. What sort of PPE you give them is going to depend on what their jobs are. And there are standards issued about that from OSHA that should be followed. I've got a link to those at the end. These are some of the examples of the PPEs. And again, looking at the way you can change up the workplace to give the folks that need to be there more space to do their duties without risk of exposure. Finally, it's very important, whatever you're doing, all efforts you're taking, make sure you have a written protocol and you're also snapping pictures of everything that you've done, measures you've put in place so that you can prove them later. One of the things that I wanted to note that I saw in the investigation guidance about good faith efforts and our employers complying with the COVID-19 requirements was this particular requirement that the investigator from OSHA may actually analyze whether there are special protections being provided to the CDC's high-risk employee. Now, we've talked about that before in the past. The EEOC specifically prohibits you from inquiring about any underlying conditions of your employees. The EEOC allows you to make medical inquiries that are tied to specifically the COVID-19 symptoms. That's absolutely fine, but you can't get into what other underlying conditions folks may have and how you think they might be aggravated. So I think the remedy to this, to meet both the OSHA requirement as well as comply with the EOC requirement, would be to include this in whatever announcements you're putting out for your safety protections. Maybe it's all in your COVID-19 policy, or maybe you have different, a list of protections by job classification. But in that, I would want you to add something general that reads along the lines of, additionally, those employees who meet the CDC high-risk definitions should be encouraged to advise HR if any of these apply, so that we can issue more protections. And so then you're still following the EOC guidance by allowing them to bring it up with you. OSHA reporting. COVID-19 is a recordable illness, so you do have to report it on OSHA Form 300. And you are also responsible for performing cases that meet the 3 criteria that I have listed here. Whoops, sorry. Trying to get the questions a little bit lower so I can read all those. It's has to be a confirmed case of COVID-19 as defined by the CDC, and that the case is work-related. The confirmation, the diagnosis is work-related, meaning that the work environment either caused it or contributed to it, or significantly aggravated a pre-existing injury or illness. And work-related exposure is presumed for exposures occurring in the work environment. Then, in addition to that, the case has to involve one of the listed criteria. They added significant illness or injury diagnosed by a physician to the usual list of what is considered a criteria before you have to report. So that would include a diagnosis of COVID. In many situations, it may not in all. Excuse me. One of the things that OSHA is doing to protect employers who are not healthcare providers or emergency responders is to give them a little leeway and not enforce some of the same requirements that the other healthcare providers and first responders are, is if you can show that you have done good faith efforts for implementing their recommendations that they outline in COVID-19, and also that you had no objective evidence that a COVID-19 case was work-related. Now, what's interesting about this is the example that they give is close working conditions without explanation. So I read that to mean if you have people who are not maintaining social distancing, even in a situation where their positions otherwise permit them to do so, and you are aware of it, then this exception, this discretion that you would otherwise get would not apply. So what that's going to translate into is that the people who are in charge of supervising your workplaces are going to have to be vigilant about maintaining social distancing when you've already reached the determination that it's possible for duties. And it's going to be interesting because I think that's where issues, these things are turning political, amazingly to me, but they're turning political away from science. And so you've got many people who are so mad that there are even protections out there. And a number of folks aren't even adhering to any of the current recommendations. And so you're going to have to make them do that in your workplace, lest you not be able to avail yourself of this general discretion. OSHA otherwise recognizes that it's going to be pretty hard for employers to figure out whether or not it was the workplace or the grocery store or anything else that resulted in the workplace exposure. All right, so here are the reporting requirements. Fatalities within 8 hours, inpatient hospitalizations within 24 hours. So that was one that has been added. If you get a written request, you've got 5 days to respond and you've got 15 days to provide documentation. A word of caution in regards to any rapid response investigation. When you are providing data or information, the plan, obviously the goal of a rapid response investigation is to get to the root cause of the problem. But please be advised that the OSHA investigator can monitor the situation for a year and can also use any of the things that they found in root cause, and then throughout the remainder of the year to come back and do another investigation and issue a citation. So you want to be careful what you put, and you want to consider getting counsel. Sorry, I'm having a hard time getting the little arrows to show up. There we go. Sometimes the little arrows go away. All right, so here are the list of some of the standards. The COVID-19 standard is a guidance. The remainder of the standards issued are enforcement memorandums. 4 of them deal with how you use PPEs. And so PPEs and N95 respirators, any sort of company that is using a respirator needs to look at the 4 different guidances in regards to respirator protections. There are also guidances about the PPE standards outside of the respirators. The good faith compliance guidance I already mentioned. Here are the references from OSHA, so these will be in the slides. Now, real quickly, I want to address an employee refusing to return a report. I'm getting lots of questions like that. So there are a few things you have to consider specifically under OSHA. Unless they're in imminent danger as defined by OSHA, they have to return. What we need to understand, though, is that it could be imminent danger for some folks to come back to work, even though everybody else is coming back to work and there are positions for them. The same thing that would qualify them for FFCRA leave, or after that 2-week expires, then
Chris, I just lost your audio.
Oh.
There you go.
Oh, good. I think it's because, bless my heart, I covered up my microphone. I'm sorry.
It's all right.
I can't stay still when I talk. Thank you, Perry.
No problem.
So I'm not sure how far we got, but so in a situation where you have someone who's going to qualify for FFCRA leave, and they would have the right to that leave, the EPSL, the 2 weeks paid leave, because their provider said this is somebody who has an underlying health condition who should not be coming to work, even though everybody else is at work. That person probably will also qualify for a concession here under the OSHA exception. Because if you read the OSHA exception, it sounds pretty stringent, but I think you have to be careful how you proceed with the folks whose providers have said they cannot come to work because of their underlying condition. So we've got some general recommendations on these last 2 slides. I will tell you, I am seeing employers who have still not implemented any OSHA COVID-19 policies and are operational or are about to resume operations, that are not engaging in any sort of requirements that employees report symptoms or any daily inquiries. So this is pretty important. We want you to, as I indicated earlier, document, address and put in protections, put tape down, do whatever you need to, and then take pictures of it. Don't forget to refer back to the EOC's pandemic guidance. Whoever is performing daily inquiries or doing any testing need to make sure that those folks know about HIPAA privacy and security rules. If you're self-insured, you probably have already had someone have this training, but if you hadn't, you're going to need to do some quick training fast before they start doing this for you, and then circle back with your normal HIPAA privacy, security, PHI protection training. When you are addressing employment laws that are implicated by FFCRA and other employment laws, I think it's still advisable to seek advice and help deal with those. Rarely do they come in a neat little package. Here are a list of processes that I recommend, or that we all recommend, that you put into place. It's sort of a checklist. Somebody asked yesterday for today's presentation, how are you tracking? So one of the things that we want you to implement is an accounting and payroll process. It's very important, as Perry noted too, that you're tracking what type of leave people are taking. And you'll need to put in accounting functions and payroll functions so that your employees can enter their time for FFCRA leave in one way and other leaves in other ways, so that you'll be able to show later which leave was FFCRA and which leave was other leave. You also want to make sure you are meeting record keeping, and what I'll speak to right quickly there is that my recommendation is you have everything you've done for COVID-19, even in daily inquiry forms that you're getting back from employees that might have personal health information. And then you've got what you're doing with your individual files and the ADA personnel the confidential ADA personnel files. Both of those files need to be kept under lock and key. Both of those files are protected, and the information contained in them need to be kept secure and secret. Under the ADA, the only folks that are allowed to know are those with a true need to know. Last question we got, and then I'm going to stop and let Perry jump in with some of the questions I know that he was going to cover. The last question we got was, oh shoot, Perry, go ahead, because now I'm having a hard time remembering exactly what it was.
Okay. Yeah, and just to add to that, I think I've gotten a lot of questions going back to Chris's point about employees that don't want to come to work, or who may have a note saying they shouldn't come to work, or scared to come to work or whatever. Those just need to be handled very carefully, and I think considered carefully as to what the reason is that the employee, really drill down on what the employee is saying that is the reason they can't come to work. Obviously, you've got the OSHA's imminent danger requirement that Chris mentioned, so you certainly don't want to be putting anyone in imminent danger. You've got the Americans with Disabilities Act that may require leave as an accommodation if somebody's got a disability that puts them at risk. There are numerous issues at play there. Generally speaking, if somebody, does not qualify under any of those reasons, the FFCRA or ADA, or qualify under normal FMLA or whatever the case may be, then generally speaking, you can require them to come to work and enforce your attendance policies, but you do have to be very careful about that. The other thing I'd mentioned, and I know it's really beyond the scope of today's presentation, is in regards to, testing employees now that everybody's coming back to work. I know there's a lot in the news about these very large companies like Walmart and other companies, taking every employee's temperature before they come into the building. And I've had clients asking me if that's a good idea. It may be something that you should consider. I'll tell you that what health experts are telling us is that it's not its effectiveness in stopping this is very questionable. and it's also fraught with legal concerns and legal considerations as far as privacy and record keeping and that kind of thing. So I would be careful before you just jumped in to the water, both feet, with taking everybody's temperature before they walk in the door. Because we're not sure how effective it is, although it could be, it could be used to show that the employer was actually taking positive steps to safeguard employees in response to an OSHA investigation or a negligence complaint or something like that. But, its effectiveness is questionable. It's fraught with legal considerations. So I'd wade carefully into that realm. I think, maintaining, following Chris's guidelines that she outlined that OSHA and the CDC have put out about personal protective equipment, social distancing of employees, disinfecting of the facility, all of those things I think are more practical, less draconian measures that, you can take that aren't quite as fraught with the legal ramifications. But with that, we do have a couple of questions. I've answered the ones that we've gotten, I think all but one that was just asked.
Barry, while you're reading that, can I go ahead and address some of the other questions while you're looking at that and thinking about that one?
Sure.
And I also wanted to weigh in on what you said about the temperature. So all those things that Perry said is absolutely true, particularly the HIPAA and privacy security. A lot of times the folks that are doing these have not had that training. But I will say that I read one thing that said it probably is a great deterrent for those employees who want to come to work with a fever anyway. Still, I mean, that's not an amendment to what Perry said. It's just maybe even just anecdotal. Real quickly, I wanted to address the question that I had to go back at my list and look at. What obligation does an employer have to inform coworkers when an employee develops symptoms of an illness, leaves, stays home, or once a positive test report is positive test result is reported? No obligation to ever tell anyone who was diagnosed or who might have been at work and exposed to other folks. And in fact, it's important that you keep that information quiet. They may be able to figure out who it is, but you should never divulge that. You can communicate to the folks that were in the area that there may be possible exposure, and you can always send those folks home. Although there's no requirement to do that, you can send them home and clean and then have folks come back. That's going to kind of depend on what your workplace is like. And so do keep that in mind, but don't ever communicate specifically who. Sorry about that, Perry. I just wanted to go ahead and get to that question.
No, I think that's, I think that was really important. And we've had a lot of questions, one which was submitted to us ahead of time about, who you notify in certain circumstances if one of your employees or customers has it. As a general rule, employers are not obligated to report to DHEC confirmed cases of their employees. There was some question, Chris and I were emailing last night about if a healthcare provider is also the employee. But generally speaking, if you're not in at least the healthcare context, you don't have an obligation to notify DHEC. If there was also a question about notifying customers. Do you notify customers that, hey, one of our employees has this? You may have been in contact with a customer. That's a much more tricky issue that there certainly, as far as I can tell, would not be a legal mandate that you put out some kind of notice to your customers of that fact. I think certainly you take all the necessary measures to quarantine and close down if need be and disinfect the facility. But whether or not you reach out to specific customers that you knew they came in contact with, some of that falls into the kind of business decision PR context. From a legal standpoint, I think the only risk you run in sort of withholding any type of disclosure like that is if a third party actually contracts COVID and, God forbid, is seriously ill or dies or something like that, and they try to assert a third party negligence claim against you saying that, you didn't take reasonable steps to warn me, you knew I came into contact with this person. So I think those are going to have to be sort of looked at on a case-by-case basis. Don't think there's sort of a blanket rule on that. One other question, just trying to tick these off. We also got a question about the PPP funding and sort of the 8-week period. So the question was in regards to the company received PPP funding on April 13th and have biweekly payrolls with the most recent payroll period ending on 4/19. So it effectively, the payroll date covered payroll expenses that happened before they got funded. This is a very unclear area of the PPP that we're still waiting on SBA guidance from. The way the law is written, it says payroll costs incurred and paid. So the way they've written it, it would seem to suggest that the costs have to be both incurred and paid out in the 8-week period. I'm not sure that's what Congress intended. Typically, when writing legislation, you should use an or instead of an and if you could use either one, but they've chosen to use and. So I think we have to advise the safest interpretation of that is that those costs have to be incurred and paid within the 8-week period. And there's a follow-up to that about, could we hold off and wait until the next payroll, start it then, and then will the 8-week clock start at that point in time? And the answer to that is no. The 8-week clock does start running immediately upon receipt of the funds. So you've got to use it within that 8-week period. That's all of the ones that I needed to answer, Chris.
I'll just hit a couple more. We're at 102, so we won't do too many more. Best practices for keeping records on contacts and tracings of those employees with positive test results. So to the extent that you don't have accounting practices now to capture the different types of leaves and stuff, you do need to put that into place. And then in regards to keeping up with any employee who's been diagnosed or who has symptoms, you need to have that needs to be addressed in your COVID-19 policy. That needs to be a required reporting situation. And in those situations, the employee who has the symptoms and or has been even exposed to somebody else who has COVID, you're going to want to know that because you're going to want to implement a quarantine of your own if necessary under your policy. In addition to that, if they end up having a diagnosis of COVID-19, just like with any other serious health condition or other illness, you would have them report to you and keep you posted. And I think you have to anticipate that might go over the 2 weeks, but still that wouldn't mean they wouldn't have to keep you informed of their recovery. I think the very last one we should cover that's a general one would be, is an employee entitled to 12 weeks of FMLA and 2 weeks of FFCRA? And I think we've interpreted that to mean yes. An employee is not entitled, though, to more FMLA than they would otherwise have under the FMLA. So if they used some of their FMLA earlier in the year and they hadn't rolled back on, then they would only be entitled to the amount of FMLA that they have left. And that would also apply to the EFMLA under the FFCRA. So I think that should probably be it. I see one other. And so I think probably we'll answer these offline. It being, I think, 104. I know one of the ones that wrote and the other two. Y'all want to add?
No, thanks everybody for joining today. We'll try to answer these. I think we might have had maybe 1 or 2 more sent ahead of time. So we'll do our best to answer these, as we can. But otherwise, thanks everybody for joining today. It's always good to hear your questions and find out what it is that y'all are dealing with as the boots on the ground. But stay safe, healthy. I hope everybody's getting business operations back up and running, and hope you've got customers and demand for your services and all that good stuff. So reach out to us if you have any questions.
Thanks for joining this webinar presented by Hainsworth Sinclair Boyd. To learn more about the firm and its services, visit hsblawfirm.com.